Now we would go into the finer aspects of the theme after delving into corporate governance and risk management. We are very fortunate to have a very noted and renowned cyber expert, legal expert, Advocate Mr. Prashant Mali. So it's fortunate to have him here. I welcome him to the dais. Round of applause, please. I now invite Mr. Pramod Nayak on the dais to offer our speaker a basket of fruits to welcome him. Mr. Prashant Mali is an advocate. He is BSc in Physics and MSc in Computer Science, LLB, CNA, and also he has a DIP in Yoga Education. He is President of Cyber Law Consulting, a legal firm of attorneys and advocates. He is country's cyber law forensics cyber security expert with strong ID security background. He is a founder faculty for a postgraduate course for CAs, namely Diploma in Information System Audit from Institute of Chartered Accountants of India. He's a regular speaker in national and international conferences, seminars, and I've also trained Mumbai University professors, Maharashtra Police, Indian Air Force, various boards of directors, corporates, and other law enforcement agencies. He's authored books on cyber law and cybercrime. His articles on e-extracts, e-contracts, software piracy, data theft, digital signature has got published in leading magazines. He's handled corporate clients like Crompton Greaves, Larsen & Toubro, ITL, Reliance, ADAG, Bharti Airtel, IndusInd Bank, ICICI Bank, SBI, RBI, Honda, Iranandani Group, CL Cars Private Limited, Camlin Group, UTI, and various government agencies, to name a few. He is regularly consulted by Maharashtra Police and other law enforcement agencies of the country. With that, I hand over the dais to Mr. Prashant Mali to take us through legal aspects in ID security and is your organization up to date. Thanks.
Thank you, Sundar. A warm good afternoon to you guys. I think we talked about risk in the morning. I'm going to talk a little further on the risk. When risk gets converted to threat and threat gets converted to crime. And I think if you see a broader aspect of the cyber fraternity, some or other person, some or other organization has burned their fingers with some or other kind of cyber crime. And many of the time it happens that the crime committed by the staff or IT professional is out of sheer innocence. So how do the law stands and law looks at all the aspects of IT? We're going to look shortly. But I'm going to focus my presentation on the corporate responsibilities towards the IT Act. See, people keep talking about the Data Protection Act of UK being the model. But if we look at our IT Act, that is Information Technology Act 2008 amendment, and the latest IT Rules 2011, you will not find a single gray area where government has not defined any aspect of the IT security. Let me take you one step further to the risk governance process. IT Act now has, in fact, with the IT rules in place, mandated that every single organization, whoever are managing, storing their data, should be IT Act compliant. Now, the IT Act compliance sometimes goes beyond the boundary of implementation of ISO 27001. Now, people or the organizations who have implemented ISO 27001, they should be at first rung be happy about it, because they are almost more than 90% compliant to the IT Act. Now, how does this affect? Let's go through our presentation journey and have a look at it. Now, what is the section which makes all the corporates responsible towards IT Act? Let's look at section 43A. Now, it is talking very categorically about, this is extract directly from the Act itself. It talks about any corporates which are dealing and handling any sensitive personal data. Till April 2011, sensitive personal data was not defined. So if you find even DSEI's manual, sensitive personal data was not defined in the DSEI's cyber investigation manual then. But now, government has defined what is sensitive personal data also. Now, so it says, whoever owns, controls, or operates. Now you see, I think the wide range of people will immediately come under the ambit of the section 43A, because you either own, control, or operate the data which is in your possession, okay, and is negligent in implementing reasonable security practices. Now till April 2011, this reasonable security practices were also not defined. Now, come April 2011, this reasonable security practices are also clearly defined by IT Ministry and Government of India. Okay, we're going to come to it after this. Because of you, organization failing to follow reasonable security practices, if somebody gets wrongful gain or loss, then the organization is responsible to pay compensation. Now let me tell you, if you could see the colored part, it says the limit is not defined. Now what does that mean? Before this act, the limit was defined. Now let me give you an hypothetical case. Suppose a data theft has been done on your organization. A data theft has been done on your organization. Your organization, and the data theft is been done by some of your employees. So if a data theft is done on your employees, you have a criminal section called section 43B, where you can go to the nearest police station and register a complaint. If you want little hi-fi investigation, you can go to the cyber police station, which is present here in Bandra, or which is there and across different cities. Under 43B, and read with section 66, the penalty is only for 3 years imprisonment and 5 lakhs of penalty. If you're not satisfied with this, you feel that my data which was taken away, stolen, was far more important and it has cost me losses to the tune of crores of rupees, you take the help of section 43A. Up till 5 crores of loss, you can go to the IT secretary of the state, Maharashtra IT secretary, who happens to be a secretary of the minister also in Maharashtra. He will give you an audience, hearing, and order. Above 5 crores of rupees, you can go to any civil court, the civil court of proper jurisdiction, and file a case and ask for compensation. Now imagine a smaller case, like suppose a data of your client is actually at theft. Like suppose an X organization is an IT organization and the data is of the client itself and that has been stolen. Imagine how cascading responsibilities you immediately get into. See, prior to 2008 amendment, if you have a hacker in your organization, suppose one of your employees using your infrastructure hacks into some other network. Hypothetical case, this keeps happening, but initially, before 2008 amendment, the person who does that hacking himself was responsible. But with this amendment, what happens is, looking at section 43A, I'm giving you the interpretation. Section 43A says, because the organization didn't follow reasonable security practices, you actually abated the staff, the hacker, you helped him to hack into other network. So the only staff or the hacker doesn't come into play, but even organization is pulled into it. And why organization also is pulled on? There is a logic beyond it. See, the company who is going to claim compensation and the hacker who is going to pay the compensation, he may not have net worth for which the compensation is claimed. So if I pull an organization, at least I can say good for the losses committed for the organization whose data has been lost. So see how grave the situation has become. Now this also allows you to do via arbitration. Like suppose you don't want to go either to the secretary nor to the court of law, then you can appoint an expert arbitrator and have this matter settled. This is how many corporates are settling this matter of data theft and technology theft. This keeps happening. Okay? So section 43A has made you so responsible. So what is a body corporate? People ask, are we a body corporate as per the act? So if you look at this definition of the body corporate, it clearly says it means any company and includes a firm, even a sole proprietor. So when we talk about sole proprietorship, chartered accountants, advocates, architects who have client-related data, everybody comes into the ambit of section 43A. And if some data loss happens, even educational institutions, they also come because you have client data with you, right? Students are, and you share the data along with all the telecom operators, insurance companies, banking, everybody just flows into the ambit of section 43A. What are the exceptions to this? Government organizations. Okay. Now, from where the data almost every time gets leaked, they are exception to this. They are not covered here. Okay. So, you always have some funny movements in every act. Now we are trying to define, many of you may not be knowing by now, because the rules are very new, pretty new. What is personal information? It has been defined in section 2(1) of I of IT rules 2011. Now this is what personal information is defined. Personal information means any information that relates to a natural person, which either directly, indirectly, in combination with other information likely to be available with the body corporate is capable of identifying such person. So complicated, no? Okay, it's all round. Let me give you very simplified format. What is personal information? Photograph of a person, name of a person, age of a person, email of a person, mobile phone of a person, PAN number of a person. This all identifies that person. Okay, so these are identifiers. If you are harboring these identifiers in your databases and you are not following reasonable security practices, there are lacunas there. And because of this, a data theft is committed on you. So you also get indicted into the section 43A. Now, it is further defining what does actual sensitive personal data is. Password is sensitive personal data about the person. Financial information such as bank account, credit card, debit or payment instrument details. This comes, so let me tell you, we have a lot of banks, they are aggregators. Banks or financial institutions, they have started working as aggregators. They are aggregating all the accounts, portfolio management companies. They have personal data about bank balances, portfolios, credit card, debit card details, investments, SIPs into one place. Imagine this data about a HNI or a normal person for that matter gets hacked about all his personal information, they come under this ambit. Digital signature is another thing. I'll come to it a little later. Physical, psychological and mental health condition. So whom do you think this is meant for? Doctors and hospitals. Means we never, hotels would come under the ambit of IT Act. They have immediately come under the IT Act with this kind of definition from the government of India. Sexual orientation. There is a gay or what are his preferences. You really can't share. Now let me tell you, Google is an excellent profiling search engine. I think everybody knows this, right? Whatever you search on Google is been stored by Google to sell across various clients. What are your tests? What do you search on Google? Okay, everything is stored with them to market to the right person, to the right client. Okay. Now imagine, do they come under this ambit? Obviously, if they are sharing so much amount of time, okay, so much amount of data, medical records and history, biometric information. Now why this biometric information? Let me tell you, I have evaluated so many ISMS policies of organization, large organization, mention of biometrics is very less in this ISMS. That's why I said, when you implement ISMS 27001, you are 90% compliant to the IT Act. 10% still remains. The idea was this. See, biometrics, I think everybody nowadays, you in your organization have that fingerprint system where you take people in, okay. In some organization, you have retina scans or signatures or palms or face recognition things. Now, these can uniquely identify that person. And with the UID coming okay, with the UID in the market, biometrics has suddenly taken up a center stage issue in India. I think people who must have applied for UID, they know India is a typical case. You know, we can't scan our they don't take fingerprints. They take hand scans, complete hand scans. Because in India, we have people who have fingers without fingerprints. Okay, because we have laborers and people, hard-working people. So they complete scans. So that's how biometrics has become important. You really can't share biometric information with people. Now, what is the exception? Exception is whatever information that is available under Right to Information Act is not considered as sensitive personal data. Now, this is a huge contradiction, you see, what the law has meant itself. Okay, you get something and then you say it is also available with Right to Information Act. Okay, if it is available with it, I got it. Okay, so there are always loopholes created in the law even. Okay, now this is typically for the appointment of grievance office. I took this because I see a lot of websites, corporate large websites, which have agreements, those terms of usage, disclaimers, privacy policy, which are pure cut, paste, copy operations from other websites and very less relevant to their own website. Now, by law, every single website, I think everybody agrees to this, website is a brochure. It's a brochure for outside world, right? So in fact, it is an invitation for people to do business with you. I think everybody agrees with this. Okay, it's an invitation. You are trying to showcase your products on your website. Okay, and if something goes wrong with your services, they can take cognizance of the conditions written on your website. You wrote something on the website and now you're not giving us those services. This can be easily a plea taken by them. So therefore, you need to have a grievance officer appointed and his name and contact address written on your website. Suppose he is only your e-commerce buyer. Then whom does he go to? Point number 2. Your IP address or your website has been found sending him unsolicited pop-ups or unsolicited emails. Then where do we go to? So therefore, this grievance officer, mark my point, very important, because you may have audits conducted, note this point very clearly, you may have audits conducted by some central government agencies on your websites or on your IT infrastructure. Government has this power to do it. And if you have been found violating, then the report may go to the nearest police station because it has not clearly said which law enforcement agency will actually correct the deficiencies with your security practices. Okay, it depends upon how strict has been the violation on your part. Okay, now he should redress it in 1 month. Please note that he should redress it in 1 month. I didn't highlight it. So he should redress any kinds of complaint in 1 month only. Now websites should have this legal notices. Now it has come from section 3 of IT rules. Now there has been a lot of hot discussion going on. Who is an intermediary? Do we come under intermediary? Because these rules are majorly meant for intermediary. As I defined earlier also, if you are managing data, holding data, you come under the ambit of intermediary. Okay. If you are having data, controlling data, so you come under this ambit of intermediary. Okay. Now they should follow due diligence